So you went to sleep around 10?
Yeah.
Okay, and then what?
I woke up.
You killed her? All right.
The case of Derek Rosa, the teenager accused of killing his own mother while she was asleep beside her newborn, has been shocking Florida for nearly 2 years. Now, the judge at the center of it all has made a decision that could change the course of this trial. Was he forced to step aside, or will he stay on the case? Well, we're going to break it all down with a Florida criminal defense attorney, and let's talk about it right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Now, if you've been following us for a while, you are well familiar with the case of Derek Rosa, who at just 13 years old called 911 in the middle of the night and allegedly confessed to something unthinkable, that he killed his own mother. Police, they rushed to this scene, and what they discovered, it set off one of South Florida's most chilling criminal cases in recent memory. And now, after nearly 2 years, the judge at the center of it all has made a pivotal decision about whether or not he will stay on this case. Now, before we get to that ruling, we're going to rewind. It's October 12th, 2023 in Hialeah. Inside a small apartment, 39-year-old Irina Garcia is asleep beside her newborn baby's crib. This is Rosa's baby sister, 14 days old. And a few doors away, Rosa is awake. Hours later, police say he would stab his mother more than 40 times while she slept, leaving that infant, thankfully, unharmed in her crib. And moments after this attack, officers would arrive to find a scene that would shock this community. And you have a son who would calmly call 911, seemingly confessing what had just happened. There is body cam from the early hours after the crime that captures Rosa's apparent confession.
So you went to sleep around 10?
Yeah.
Okay, and then what?
I woke up.
You killed her? All right. What type of knife was it? Do you know?
It was just a big size kitchen knife.
That big?
Yeah.
What color was the handle?
Purple.
Purple?
Yes.
Okay. Your mom was sleeping?
Yeah, she was sleeping.
Okay.
Now, he allegedly tells police that he used a kitchen knife with a purple handle, and then instead of choosing to unalive himself, he called a friend online, an acquaintance that he didn't even really know by real name, and sent them photos.
I intended to show myself before, but I couldn't.
Okay. And then what did you do?
I decided to call my friends to tell them what happened.
How many friends did you call?
Only one.
What's his name?
I don't know his real name. He's an online friend.
Did you tell him how? Or no? How you killed her or no? Okay. Did you send them any pictures?
Yes.
How many pictures did you send them?
I sent him 2 of my mom and then 1 of me.
Okay. Did you... What did he tell you?
He said he couldn't believe it.
Why did you kill your mother? Do you know?
If I had to say it now,
Yeah, get it off your chest. Absolutely.
we can wait for a lawyer.
Okay, at this point, you want a lawyer?
Maybe not.
We can't. No, listen. Just so you understand, okay? You have mentioned or asked us, should you wait for a lawyer? We're not here to advise you on whether to talk to a lawyer or not. That decision is yours, okay? But if you are requesting a lawyer at this point, we can't interview you any further. You understand? We have to stop the interview.
Okay.
Do you want us to stop the interview?
Yes.
Okay. Then this interview will end right now.
It is 3:05 a.m.
Okay. Thank you.
So Rosa was taken into custody. He was charged as an adult, by the way, with first-degree murder. And as prosecutors continue to build their case against him, they have amassed chilling evidence. Maybe the most haunting pieces of evidence aren't from inside the bedroom at all, but from outside. You have 4 short video clips that were captured on the family's home security system. Prosecutors released them last year. In one of them, Derek Rosa can be heard on the phone, calmly giving someone his apartment number.
201.
In another, he seems to mumble something in Spanish to his mother about a possession that wasn't working properly.
Okay.
But I gotta say, maybe the most chilling clip, it lasts just 8 seconds. Rosa walks into the apartment. In the background, his mother, Irina Garcia, is seated in a chair, breastfeeding her 14-day-old daughter. And hours later, police say Garcia would be stabbed more than 40 times as the baby lay nearby in a crib. You know, I gotta say, I have a demanding life as a reporter, a journalist, an anchor. I need fuel. I need fuel to keep my energy up throughout the day. But what do we see? A lot of these supplements and bars that are meant for on-the-go snacking, they're a mess. They have misleading labels, they have really complicated ingredients. That is why I'm so happy that we are partnering with Equip. With clean nutrition in mind, they are all about real food first. Transparent sourcing, third-party testing, there's no toxins or fillers sneaking in. Their Prime Bar, it's not just another protein bar. It is a grass-fed beef superfood bar that tastes like dessert. But instead of the junky syrups and the seed oils, Equip is built with real functional ingredients, like 20 grams of pasture-raised protein and dates and honey for natural sweetness. I keep a box on hand for when I need that, midday sweet fix, and you can too at equipfoods.com/sidebar. You guys are going to love how clean and delicious these bars are. They're going to be a household staple for you and your family. Equip, by the way, is giving my audience an incredible offer. You can hit the link right here or go directly to equipfoods.com/sidebar. Use my promo code sidebar. You will get 20% off of your first order or 35% off of your first subscription. So thank you to Equip for making the best bar on the market and partnering with us. And the final video shows Rosa after the stabbing speaking almost casually into a phone as police arrive outside.
I see officers. Do I leave? Do I leave my house?
Do not leave.
Okay.
Stay there where you are in your apartment.
Moments later, red and blue lights, they wash across the screen as officers pull into the parking lot. Now, the baby monitor images from inside the newborn's room, they appear to capture Rosa's mother lying down next to the crib at around 10 in the evening, and less than an hour later, images appear to show Rosa on top of his mother just before or during the killing. And from the start, Rosa's attorneys have argued that their client, barely a teenager at the time, deserves compassion and fairness from the system. But what has happened? In recent months, their focus has shifted to the judge overseeing this case, Circuit Judge Richard Hersch. And a motion filed earlier this month, Rosa's defense had asked this judge to disqualify himself, saying that his behavior had crossed the line from firm to biased. Now, we will get into the details of this motion, but to help break it all down, I want to bring on Florida criminal defense attorney Kaysia Earley. Kaysia, thank you so much for coming on. It's so good to see you again. How unusual is it for a 13-year-old to be charged as an adult in Florida, particularly for first-degree murder?
Yes, well, unfortunately, it's good seeing you, Jesse, as well. Unfortunately, if you reach the age of accountability and the charge is as serious as first-degree murder, oftentimes the state attorney's office, if information is filed, will direct file that juvenile out of the juvenile program into the adult facility. And this is what happened here, with the exception that there was a grand jury indictment that charged him as an adult, even though at the time he was 14 years old. So it is common based on the severity of the allegations and the charge.
Now I want to talk about this motion. What is the legal standard by which a judge has to be disqualified for alleged bias? And by the way, a judge deciding they're bone biased, I mean, how does that work?
Yes, I mean, it's the fine line, because based on the motion, the court, which is the judge in this instance, if you take the allegations as true that that judge is not being a fair and impartial judge, then oftentimes what a judge will do is recuse themselves. But there's been times when it's a well-written motion by the defense and the judge has refused to recuse himself based on the allegations or based on the alleged conduct. There has to be more than just a complaint or the appearance of the judge being unfair. And oftentimes when the defense draft these motions, they typically attach a transcript. Let's say there was an initial initial hearing and the judge did not allow them to have access to the record or made some egregious comments from the bench. A transcript is usually attached to that. And if the judge decides, well, these allegations are not true and decides not to recuse himself, there's always a higher court. But usually it has to have more evidence than your belief, your subjective belief that the judge is being unfair.
Do you see that often, judges being unfair in high-profile, heinous crimes?
I see it in regular trials. I mean, I've filed my share of motions to recuse a judge. Usually it's when the judge lacks judicial temperament, when the judge is just being extremely rude. And you may say, well, what's the reason that you would file a motion to recuse if a judge is being rude? Well, if a judge is talking down to you, cutting you off and not allowing you access to the record, then sometimes your client will see that behavior and lose confidence in you as counsel. So it's imperative that the judge not only follows the law, but exhibits the proper judicial temperament so that we can zealously advocate for a client. So I filed motions in the past to recuse a judge if I believe that my client was not receiving a fair trial. And some have been granted and some have been denied. And
by the way, before we move forward, what are the unique challenges that a defense attorney faces when they're representing a young person like this, accused of a violent crime, a juvenile is being tried as an adult? What are the challenges there?
Several. I've had many cases, and in fact, I worked at the Assistant Public Defender's Office in Broward County initially in the juvenile division and then in the adult facility. Typically, the challenge when representing a client, whether it's an indigent client or someone being accused of a crime, specifically a juvenile, you want to ensure that they're first competent to proceed, that they understand the legal basis, they understand the procedure, the charges. And if they do not, I typically request a competency evaluation just to make sure that they understand and they're able to assist me with their own defense. And if that's not sufficient, there's sometimes that I will request a forensic psychological assessment, whether it's an educational assessment, to see if that juvenile or defendant has some educational developmental delays. Because if they cannot assist me in their defense, it's going to be hard as their defense attorney to provide a proper defense during trial.
So let's get into this motion, okay, about the disqualification. Now, when Rosa's lawyers filed their motion to disqualify Judge Richard Hersch, they didn't really mince any words, saying, quote, Derek Rosa's motion is based on a well-grounded fear that Judge Hersch is biased against him. This fear, amongst other factors, stems from Judge Hersch's actions and attitude against Derek Rosa and the defense. And the motion laid out what they called a disturbing pattern of, quote, animosity, hostility, mocking comments, lack of temperament control, inappropriate tone, inappropriate gesturing, inappropriate comments, disparaging comments about Rosa's medical conditions, and overall expressions of disdain and dissatisfaction this court seems to have against the defense. One example, the filing accuses the judge of mocking Rosa's diagnosis by making air quotes, writing, quote, this court has made undermining and overall disparaging comments about Derek Rosa's medical history and condition, specifically his mental health, in part gesturing air quotation marks when referring to Rosa's autism diagnosis. And it also points to comments the judge allegedly made in open court, saying Judge Hersch has openly expressed that this isn't a whodunit case. These comments have been made in open court as well as privately. These are inappropriate, conclusory remarks regarding Rosa's guilt in this case. And the filing closes with a pointed rebuke of Hersch's conduct. Quote, this motion is filed based on, amongst other factors listed above, this court's clear indications that he has already concluded that Derek Rosa is guilty of murdering his mother, and this isn't a whodunit case. This court has exhibited, as recently as August 27, 2025, numerous instances which display his inability to rule impartially in this case. As a result of the above-referenced actions, a reasonably prudent person would be in fear of not receiving a fair and impartial trial in front of this court. Kaysia, do they have a point?
Jesse, these comments are very concerning. And if these are in fact true, I'm pretty sure that the defense has objective evidence to back it up. Also, there's other avenues that they can take, because if the judge's behavior is as egregious as the allegations, they can also report the judge to the Judicial Qualifications Commission. Because if he is not only not being fair and impartial, but mocking the defendant in this case and being disrespectful to counsel, judges are held to a high standard as well. So this is very concerning for the court, because we want to make sure that even if it's beyond obvious, even if it's a slam dunk for the prosecution, the client, the defendants are entitled to not only a fair and impartial judge, but due process. And it's impossible to have due process if these comments are backed up by a transcript or the court reporter capturing what the defense is alleging. So it's very concerning, and I'm curious as to how the ruling would be.
What could be a counter argument for the judge here? I'm being misunderstood. It's my courtroom. I'm allowed to use certain language that I want. I made comments outside the presence of the jury. It's not reflecting how I feel about the case. I mean, are those common arguments? I mean, what are things judges can say to defend this alleged behavior?
Well, first and foremost, they can just do a blanket denial of the order, deny the order.
But there is a trial transcript. There's a transcript on the record.
There is a transcript, but also the transcript doesn't take into account body language. It doesn't take into account how the words are being displayed from the court. There's always an explanation, right? He could have been making the air quotes around autism because he never received the official report, and maybe this would have just been self-serving words from the defense. We don't know. So it's open to interpretation, but as a judge, you don't want to leave that line of being unfair and not providing due process to a defense. Someone
might listen to this and say, well, wait a second, I don't care how the judges behave. How's that going to affect the jury? The jury's the one that ultimately determines whether or not somebody is guilty or not, unless it was a bench trial. Why should I care how the judge is behaving? What's your answer to that?
It's very important because although the judge is not going to determine guilt or innocence, or in this case, whether or not Mr. Rosa is guilty or not guilty, the judge is there for every stage of the proceeding. So he is the one that will make the determination as to whether or not an objection is overruled or sustained. His body language can show favoritism or whether or not he's partial to one side or the other. So this is very important. And also, if he is found guilty, the judge is the ultimate person and that is responsible for the sentence. And although he's been charged with a first-degree murder, typically lesser included offenses are included in the jury instructions. In Florida, first-degree murder is life until you die. But if there's less included, let's say manslaughter, the judge has that determination to sentence him to the highest possible sentence. So we want to make sure that the judge is fair. And if he's making these remarks and they are truly memorialized on the transcript, that is very concerning.
And if you are making this motion and you are accusing the judge of being biased, and that is denied, and let's say another court doesn't pick it up and that stays, isn't this awkward now going to trial with the judge? Do defense attorneys have to change their perception? Do they have to change their strategy a bit? How do they deal with a judge that they just accused of, being biased and wanting kicked off the case?
Which is why when you're filing these motions, you better have a good faith basis to do so. And like I said, I've done them before. They've been denied. Some have been granted. And you go right before the judge. It's professionalism. As attorneys, we take an oath of office. And you're not supposed to take anything personal. And if you want the judge to uphold the rule of law, sometimes you will be denied. Sometimes your motion will be granted. But professionalism is key. I give the judge the same professionalism, the same respect in his court. And you just work. You do your job. It's not uncomfortable, because this is our job. We fight zealously for our clients, and we also make sure that we are keeping that line of communication and professionalism open.
Have you, in your experience, please don't name names, have you seen situations where you've had a motion denied and the judge, in your opinion, acted a little bit more unfavorably towards you or your client after that, that motion? You could feel it?
Personally, I've experienced both ends of the spectrum. Typically, I usually have a judge who will respect the fight, upholding the Constitution. And then sometimes I have a judge who is offended that you even challenge the judge. And again, they have to understand that there's checks and balances in the judicial system as well. And all we're doing is making sure that our clients' constitutional rights are protected. It's not uncomfortable to me, because as long as I know the law and case law is on my side, that sets the legal precedent, we're doing our job. It's difficult, but it's our job.
And look, somebody might be listening to this and saying, this guy's accused of killing his mother. Why should I care if the judge is mean to him or biased against him? But no matter who the criminal defendant is, they do have a right. They do have constitutional rights, particularly to a fair trial. And I will say, for the cases that look the most egregious and where the evidence looks overwhelming that the person did it, you want to make sure that there were no problems during that trial process, because a conviction can be overturned and then you start from ground zero, and that's not great. Now, I will say what happened here. September 15th, Judge Hersch issued a ruling. Despite the laundry list of accusations, he is not stepping down. His reasoning was simple. The defense motion was legally insufficient. In other words, the claims, I guess even if assumed true, they don't meet that strict legal bar that requires a judge to recuse himself, Kaysia. I guess that's what we're talking about?
Absolutely. I mean, if the defense feels like they have credible evidence and they feel like it was beyond egregious, again, they can report the judge to the Judicial Qualifications Commission, or they can appeal to the higher court. There's always a legal remedy, or they can continue to take note of the pattern of the judge, because if he was that egregious before, either he's going to continue his pattern or he's going to be mindful of it to make sure that anything he's doing or anything that he's saying will not come across as being unfair on behalf of the defendant.
Could the defense use this ruling later on as grounds for an appeal if Rosa is convicted?
Well, any of the judge's behavior during the trial, that's when the jury has been sworn and impaneled. So if they have new evidence that he was not given a fair trial due to the behavior of the judge during the trial, then of course they can always file a motion for a new trial and cite that. But bringing in pretrial motion behavior from the judge for something that did not happen in the presence of the jury would not be sufficient legal basis to grant a motion for a new trial.
Could they bring another motion later on during the course of the trial? Like you said, they discover what they believe are new violations, new evidence of bias?
Of course. I mean, if they feel that the judge's behavior, especially after the trial has started, that it's too egregious, they can file that motion. But typically, that would be a great basis for a motion for a new trial. Once that jury panel is sworn in, then all of that creates greater ammunition for the higher court to make a determination as to whether his due process was violated and was it sufficient enough to have a new trial.
So now Rosa's case moves forward under the same judge that his attorneys tried to push out. By all accounts, it seems that Rosa is still being held without bond at the Metro West Detention Center awaiting trial for the murder of his mother. The defense may appeal this ruling. Judge Hersch may not be going anywhere. The trial is expected 2026. But Kaysia, you told us you were actually there. You didn't realize that this case was going on. There was another bid by the defense, right? They were trying to get him out of that facility?
Absolutely. So Rosa has a growing amount of supporters, not just his family. There were strangers there. They had T-shirts on in support of Rosa. Basically, they want him transferred out of the Metro West Detention Center into the juvenile facility. And they're claiming that he's being held in solitary confinement. This is a high-profile case, very serious charge. And the judge asked for a log of how many hours since the time that he's been in custody up until the next court hearing, or the amount of hours he has been out of his cell. Typically with solitary confinement, you're in your jail cell 23 hours out of the day, you're removed from general population. The issue with that is he's still a juvenile, but this is a grand jury indictment. So if he is convicted, he does not fall under the juvenile division, which the maximum punishment for the Department of Juvenile Justice is up to the age of 21. He is looking at adult punishment. This is not for rehabilitation. This is strictly for punishment. So it doesn't make sense in the grander scheme of things to take him out of the adult facility based on the seriousness of the charges and put him with other juveniles. So I do believe that the judge may not grant that, but it remains to be seen.
Yep, this Derek Rosa story is far from over, I'll tell you that much. Kaysia Earley, thank you so much for coming on. Appreciate it.
Thanks for having me.
And that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.